Good afternoon, everyone, and welcome to a webinar brought to you by AIA Contract Documents. This webinar is titled Guide to Avoiding Lien Disputes Using the A201 General Conditions of the Contract for Construction and Commonly Used Forms. In this program, we're going to do an in-depth look at the A201 General Conditions document, focusing specifically on provisions in the A201 that can be used to avoid lien disputes on construction projects. And realistically, we are also going to be talking about features in the A201 that can help avoid payment disputes generally, because you typically don't get a lien claim unless someone hasn't been paid on a project. We are also going to talk about a lot of forms throughout this program. There are, just generally speaking, a lot of forms involved in the kind of closeout of a project and in when it comes to lien releases and waivers. So we'll talk about things like lien waivers, sworn construction statements, contractors' affidavits, and consent of surety forms. And with that, let's get into our presentation. Of course, I have to start with a few housekeeping items. First, this presentation is protected by US and international copyright laws. Please don't copy this presentation unless you have written permission from the presenters to do so. And I cannot emphasize this enough. Nothing that you hear in this presentation is or should be considered legal advice. This presentation is offered for informational purposes only. If you do have a legal issue about a project or situation that you need guidance on, we recommend that you reach out to a licensed attorney in your jurisdiction who can provide you with legal counsel about specifics of your issue. And I am going to bring in my co-presenter very quickly, Sara, to talk about why this disclaimer is so important when it comes to mechanics liens and any issues regarding mechanics liens, because they are very state specific and there are nuanced differences between the laws of each state. Sara, you want to help us out here?
Yeah, Mike, I couldn't agree more. This disclaimer, which we'll repeat a few times throughout this presentation, just the importance of it. So as Mike discussed, we're going to be talking about lien waiver forms and other forms during this program. Lien waiver forms and liens in general are often subject to statutory requirements that are also often unique to your jurisdiction. We recommend that users consult with an attorney when completing or executing any of the forms.
Thank you, Sara. And just from my kind of practice perspective, I used to practice law in California. Just because you know the laws of California doesn't mean you know the laws of Nevada. I also used to work in the District of Columbia, and mechanics lien laws in Maryland and Virginia are different. So definitely reach out to an attorney who can help you navigate these issues better than this program will be able to do. Also, please know that this presentation is registered with the American Institute of Architects for one continuing education learning unit. If you've properly signed up for this presentation, you should see this learning unit show up in your transcript within 2 to 3 weeks. If you get to about the 4-week point and you have not seen it shown up in your transcript, please reach out to us and we will make sure you get credit for this program. So I'll take a few minutes now to introduce myself. I'm the guy on the top there. My name is Mike Koger. Currently, I serve as Senior Director and Counsel with the AIA Contract Documents Program, and I've been working with the AIA Contract Documents Program for the past 10 years. Before that, I worked in private practice as an attorney where I represented owners and contractors in construction-related disputes. And before that, I actually started my career as an architect a little over 20 years ago and practiced architecture for about 4 or 5 years before embarking on my legal career. And now, Sara, I'm going to introduce you a little bit more formally. Sara is a manager and counsel with the AIA Contract Documents Program, and I'm very relieved to have you joining me, Sara, on this program. Not only is Sara a very good presenter, but also for the past 2 years, Sara has been our guru of lien waivers. She's led our company's effort to create all the lien waiver forms that we're going to be talking about towards the middle of this presentation. And without her, this presentation is definitely not possible. Sara, you want to tell us a little bit about your background?
Well, thank you so much for the generous introduction, Mike. So hello, everyone. I've been manager and counsel at AIA Contract Documents for about 2.5 years now. Similar to Mike's background that he just spoke of, I also worked in private practice prior to starting here. I worked at a construction litigation firm in Chicago for some time where I primarily represented owners, contractors, and sureties in construction-related disputes.
All right, thank you, Sarah. So real quickly about the AIA contract documents, I want to make sure that everyone knows just a little bit about who we are, what we do, and how long this program has been around. We at AIA Contract Documents have been creating standard form agreements since 1888, and over those last 135 or so years, our offerings have really evolved to reflect practices in the construction industry. We like to say that we evolve with the industry. We do not try to create new documents that to push an agenda. All we're trying to do is reflect the current practices in the construction industry. As the construction industry evolves, we try and evolve with it. That's why we've, over the years, created construction manager documents, design build documents, and many other kinds of sustainability offerings over the years. We also have a substantial volume of interpretive case law that has really developed around the AIA contract documents. So this is courts that have actually rendered decisions on the AIA contract documents that you can actually go look up either in Westlaw, LexisNexis, or the AIA Legal Citator and find, if you want to know what a provision how a provision has been litigated, how it has been resolved in a court, or how it has been interpreted in a court, you can actually find decisions that, either in your jurisdiction or maybe a neighboring jurisdiction that might be helpful to start to solve issues that you might have with your own practice. We try and create documents that are fair and balanced, and we want to make sure that we are, to the extent possible, not using legalese in our documents. We want to make sure that we are creating documents that are expressing the intentions of the parties in plain language. The AIA documents are developed by the AIA Documents Committee. This is a standing group between 30 and 35 architects who are in good standing with the American Institute of Architects. And of course, they are assisted in that work by legal counsel like myself and Sarah, and also by insurance consultants as well. So here's how we're going to break down the presentation. I'm going to start by talking about the A201, some provisions that are in that agreement that deal with payment and lien issues. Then Sarah's going to talk about lien waivers and releases and sworn construction statements. And then I'm going to talk about contractors' affidavits and consents of surety that are forms that are typically signed and executed at the end of a project. All of those forms that I just mentioned there are very important from protecting the contractor and owner's interests, really, when it comes to closing out a project. But first, I want to set the stage by showing a few recent examples of mechanics lien claims gone wrong. These are two local news reports, and they both kind of popped up on my phone over the last few months because they're in my area. I live currently in Tampa, Florida, and both of these are, just in the last few months, and they are definitely issues that are pretty common from around where I'm at and also around the country. It's really the same story in both of these news reports. In both of these, a homeowner paid a contractor to do work on its home. The homeowner paid the contractors in full, and the contractor did the work. And in both instances, the homeowner thought that everything was ship-shape and exactly how it should be when the work was done, only to later find out that its home, the homeowner's home, had a mechanics lien claim against it from some subcontractor or supplier that, frankly, they had never even heard of. So it came as a surprise that they had paid their general contractor, but the general contractor had not paid their subs, and then they were hit with a lien claim as a result. So in other words, what happened was that the owner never got the appropriate lien releases from everyone who did work on the project to protect itself. So a couple of takeaways from this kind of stuff happens all the time. I could probably list dozens of news articles that are similar to these from all over the country showing these kinds of things and these kinds of issues. And so this is not some conceptual or philosophical issue. This is something that happens pretty often. Also, small projects are not immune. In fact, it is probably more often that these kinds of issues happen on small commercial projects or to homeowners, people who really don't know how to close out a project properly, that don't know how, or don't even know what a lien waiver release is. Sarah, do you have any thoughts or examples from your own experience?
Yeah, those are really good points, Mike. When I read through these articles, what came to mind is how certain jurisdictions require contractors to submit lien waivers to homeowners when they're performing work on residential projects in exchange for payment. And the law requires, in these jurisdictions, the law requires contractors to submit the waiver regardless of whether the homeowner requests it, regardless of whether the homeowner even knows what it is. So it sounds like that would have been super useful in these jurisdictions. And it's just yet another reason why we're going to keep emphasizing how important it is to be aware of the jurisdictional requirements in your area when in the area of your project.
Absolutely. I'm sure that is like a, consumer protection type of a statute aimed at, protecting homeowners, because quite frankly, homeowners just do not know to ask for these things. They think it might be a big burden at the end of a project to ask, somebody who's done good work on their house to ask them, well, hey, can I also get a lien release? To a contractor, this is not a big deal. If you've been paid appropriately, what you're owed, like filling out a lien release is not a big deal, and getting them from your subs is something that is pretty standard. So don't feel hesitant to do that and to ask for that kind of stuff if you are a homeowner. Okay, let's start looking at some of the protections in the A201 that start to address these issues and more. The first protection I'm going to talk about is one that benefits, actually the first two protections I'm going to talk about are ones that benefit contractors that contractors should be aware of. It's pretty obvious to say, but contractors want to make sure that they get paid on a job. And one of the best ways a contractor can protect itself from non-payment or from an insolvent owner is to make sure that the owner has proper funding for a project. The A201 has two mechanisms to allow the contractor to request information about the owner's financing, and I'm going to go through those two right now. And I didn't put the language on the screen because I didn't want to inundate this entire program with text-heavy slides, but you will find the language in section 2.21 of the A201. That's where you're going to find the contractor's right to request information about the owner's financial arrangements prior to commencement of construction. So this contractor's request must be in writing, and upon receiving such a request, the owner is required to furnish reasonable evidence that the owner has made financial arrangements to fulfill the owner's obligations under the contract. Importantly, the contractor does not have an obligation to commence work until the owner provides this evidence. And if the commencement of the work is delayed as a result, the contract time will be extended appropriately. And that makes sense, right? I mean, if you're a contractor, you want to make sure that there's money, that to pay you before you actually start doing the work. Now, after commencement of construction, the contractor's rights to request information about owner financing is a bit more limited. Section 2.2.2 is where you're going to find those rights. In this scenario, after commencement of construction, the owner's obligation to provide reasonable evidence of its financial arrangements is only triggered if the owner fails to make payments to the contractor as the contract documents require. 2, if the contractor identifies in writing a reasonable concern regarding the owner's ability to make payment when due. Or 3, if a change in the work materially changes the contract sum. So, for example, if the owner has expanded the scope of the project significantly, right, by like 20 or 30%, and there's a change order that's materially changed the contract sum, and I do think that 20 or 30% increase in that would probably be a material change, then the contractor has the right to ask for evidence of the owner's financial ability and arrangements to pay for the additional work and for the work in general. Lastly, this section requires the owner not to materially vary its financial arrangements without prior notice to the contractor. And next, I want to talk about another section of the A201 that helps to protect contractors and their lien rights on a construction project. This one is very important for contractors to know they have this right. This is the owner's obligation to furnish information about itself and about the property that the contractor would need in order to evaluate, give notice of, or enforce mechanics lien rights. In order for a contractor's mechanics lien rights to have any real meaning, the contractor needs certain information from the owner in order to take steps in furtherance of those rights. And section 2.12 of the A201 is the provision that requires the owner to cooperate with the contractor and provide that information. I've highlighted some of the things that I think are important here, but I'll talk about them in a little bit of detail. Notably, the contractor must initiate the request and it must be in writing. The first sentence is a general requirement for the owner to provide information that is, and I'm quoting, necessary and relevant for the contractor to evaluate, give notice of, or enforce mechanics lien rights. So for example, in New York and many other states, a notice of lien must state the name of the owner of the real property. Now, that might seem like a very easy thing for a contractor to figure out, but I can tell you from practice that it's not always that straightforward. The owner is not always going to be the same entity who's signed the construction contract. The owner could be a parent company, a subsidiary company, an LLC. So getting that, name, the actual name of the company that owns the real property is kind of tricky. So if you just list the owner of a property as Google, I'm just using an example, a common example here, in your notice of lien, but the actual recorded property owner is Alphabet Incorporated, your notice of lien, it might be invalid depending on your state and how strict they are enforcing these kinds of things. And this is a very good reason to use section 2.1.2 of the A201 in order to get the proper information from the owner to enforce your lien rights. Also, another good reason to hire an attorney to help you sort these things out so you don't make a mistake in a notice or in some kind of a documentation that could end up jeopardizing your lien rights down the road. The second sentence in this section requires the owner to include a correct statement of the legal title to the property on which the project is located and the owner's interest. So it's important to note that this is not an exhaustive list of all the pieces of information that the owner may have to provide. That first broad sentence requiring information necessary and relevant could require even more, depending on what what's going to be required by the contractor in order to actually enforce or to evaluate their mechanics lien rights.
Yeah, Mike, this is such a great paragraph for contractors to rely on. When I was reading this, I was thinking that many states require contractors and their subs to give notice to the property owner as soon as or shortly after they begin performing work on the project. And that would be a prerequisite to filing a lien. So this is like step one of determining whether you have a valid lien, is whether you provided this preliminary notice. And that preliminary notice may require information that only the owner has. I think an example is it might be somewhat easy to find the legal description of the site that the project is on, but sometimes that project can extend into 2 sites or 3 sites if it's a really large project. And so the legal description on all of those sites would be required for a proper lien. And that's just an example of very nuanced information that might be necessary and relevant for the contractor. So again, this is a great provision and it's really useful in those jurisdictions that require a preliminary notice.
Absolutely. And it just kind of underscores, like, don't wait, if you're a contractor, don't wait for there to be a conflict in order to start asking for this information. I mean, the owner is supposed to, should and is required to cooperate with you to give you this information. But if you're asking for this information right up front, so that if you do run into a problem later on, then you're already equipped with this kind of information right while things are going well on the project. And that's pretty common, as Sara mentioned, like that's pretty common to kind of exchange this information right up front at the beginning of a project, and so that you're armed with it when you do need it. Okay, I'm now going to turn to applications for payment. A lot of text here, but this stuff is pretty important. I'm not going to go into all the detail here. I've highlighted some things that I think are important for this presentation, but I do want to focus on some of the protected features. And the fundamental point here is that if the owner makes payment for work, the contractor and its subs must relinquish their rights to encumber the owner's property with liens and to turn over title to the work, at least to the extent that they've been paid, right? So section 931 requires that each application for payment be supported by all data substantiating the contractor's right to payment that the owner or architect require. So it goes on to give some examples of what might be included in that. And of course, one of those is releases and waivers of liens from subcontractors and suppliers. So importantly, this does not necessarily require a final release. We're talking still about applications for like progress payments. So this doesn't necessarily require a full and final release. If a subcontractor is only partially through its work, and partially through receiving payment, they should be executing a release on progress payment or a partial release. Section 9.3.3 also contains some important other protections for the owners when it comes to applications for payment. In this section, the contractor warrants that title to all work covered by the application for payment will pass to the owner no later than the time of payment. And it also contains a contractor warranty that all work performed up to that point shall be free and clear of liens, claims, security interests, or encumbrances in favor of the contractor's subs and suppliers. So again, the whole idea here is payment in exchange for unencumbered title to the work. Sara, I know you're going to talk about some of our lien waiver documents at the end of the program, but just to kind of stitch this together in real time here, can you give us the numbers or the document numbers for what we have for like progress payments in terms of lien waivers?
Yeah, and so as Mike said, we'll definitely get into the details about this later in the presentation, but we have lien waiver and release documents for progress payments, and those document numbers are the G901 and G902. As it relates to final payment, we have two other lien waivers, and those would be the G903 and the G904. All of the numbers I just mentioned, those are our generic forms that are related to lien waiver and release forms. So we have the generic ones, and then we have a variety of state-specific ones as well.
Awesome, thank you, Sara. And we'll get into a lot of those nuances of what she was just mentioning here later on in the program. It's also worth pointing out here that AIA contract documents, one of the nice features about them is that they are all coordinated. Typically speaking, if you see a requirement that would be like something that the contractor would have to provide in paper form, like a release or an affidavit, or typically speaking, we've got forms like that to satisfy that particular requirement. So just go look in our G series of documents. That's where we have all of our forms. Now, I'm sure that there are some requirements that we don't have a form for, but more often than not, you're going to find the form that you need in our G series documents if you see a requirement in the A201 or some of our other key documents. Okay, so section 968 of A201 provides another important protection for owners. And this is the contractor's duty to defend and indemnify the owner for any lien claim or claim for payment from the contractor's subs or suppliers of any tier, so long as the owner can establish that it has fulfilled its payment obligations. So remember here that the owner is not in a good position to know who all of the subs and suppliers are on a project. I mean, this is exactly what happened with the two examples that we gave towards the beginning of this program. That owner had no idea who the subs were that were working on their home. So their relationship, the owner's relationship, is going to be with the general contractor or the construction manager, who will then have their own direct contracts with their team of subs and suppliers. But the owner's not going to know who those parties are. They're also not going to be in a good position to know whether the CM or the contractor has paid those parties in full. Yet, importantly, for an owner, each one of those subs and suppliers has the potential, after providing work on the owner's property, to encumber the owner's property with lien claims. So that's where this indemnity obligation can be very important. It really puts the obligation on the contractor to be responsible to make sure that if it's been paid, then it needs to make sure that the subs and suppliers have been paid appropriately and that they're not filing subcontractor or supplier lien claims on the property. So also note here that the indemnity obligation includes reasonable attorney's fees and litigation expenses. So if the owner has to hire an attorney and spend money to extinguish a lien claim, then the contractor has to pay those expenses. Alternatively, the owner can simply point to the duty to defend obligation in this section and require the contractor to hire an attorney to extinguish those lien claims on its behalf.
Another point about that slide, you're talking about the protections of the owner for it, but I'd also like to chime in about how this is also a benefit for contractors as well, because under our A201 and our A401 subcontract, this obligation is properly flowed down to subcontractors. So this is another provision that contractors can look at and look at their sub saying, you have an obligation to indemnify me.
That's an awesome point, Sara, because yeah, a lot of these protections that I'm saying, they're protections for the owner. the way our contracts are structured, the A201 will flow down to the subcontract agreements, and the contractor can point to the subs and say, you need to be providing these things to me. You need to be assisting me in this obligation in some way. So that's a great point. Okay, so next I want to talk about final payment and the many different contractor requirements and owner protections that are built into that process. If you're an owner, the biggest leverage that you have to get a contractor to do anything on your project is the enticement of paying the contractor, either in the form of progress payments, final payment, turning over retainage amounts that are withheld, anything. So when you make final payment as the owner, you are relinquishing all of that leverage. So you need to make sure that you're protecting yourself before you make that final payment. And that is what section 9.10.2 is all about. It lists 6 things that a contractor must do before becoming entitled to final payment on the project. So the first thing that a contractor must do is execute an affidavit certifying that all bills and indebtedness on the project have been paid or satisfied. This requirement can be satisfied by using our G706 form that I'm going to be talking about a little bit later. The next 2 requirements deal with insurance coverages, and those are beyond the scope of this presentation, so I'm not going to go into those in any real detail. The third requirement is that the contractor must provide consent of surety, if there is any, to final payment. And now that requirement can be satisfied by using our G707 form. Actually, I'm sorry, I misspoke. That's the 4th requirement here. And it can be satisfied by using the G707 form. And I'll be talking about that G707 form a little bit later. The 5th requirement to final payment is that the contractor must submit things like manufacturer's warranties to the architect, who of course is then going to be turning them over to the owner. And the last thing, which maybe we should put at number 1, it's a really important one, is that a contractor must submit data establishing payment or satisfaction of obligation, such as releases and waivers of liens. And so section 9.10.2, the wording of it, you can see it makes this last item at the owner's discretion, but I would highly recommend requiring this if you're an owner to get those final lien releases from all parties who did work on the project. And one other thing, section 9.10.2 specifically states that if a lien claim, security interest, or encumbrance remains unsatisfied after payments are made, the contractor shall refund to the owner all money that the owner may be compelled to pay in discharging the lien claim, security interest, or encumbrance, including all costs and reasonable attorney's fees. So in other words, if the owner pays the contractor in full, but the contractor holds back $20,000 or something like that from a subcontractor's payment, and that subcontractor then goes on to file a lien claim against the property owner, then the contractor must refund all that money and any costs and reasonable attorney's fees to extinguish that lien. So if you can't tell by now, the A201 has a bit of a belt and suspenders approach when it comes to this whole, when it comes to final payment, progress payments, and all of the protections for the owner and requirements of a contractor. And the last protection in the A201 that I'm going to talk about before we start going through a handful of forms is the owner's right to issue joint checks to the contractor and to a subcontractor or a supplier. You're going to find this in 9.5.4, and it only applies if the architect has withheld certification for payment due to the contractor's failure to make payments properly to subs or suppliers. This is not always something that's really easy for an architect to find out. Practically speaking, I mean, I've worked as an architect before. You really don't know often if subs or suppliers haven't been paid by the contractor. But assuming that the architect does have this knowledge, is made aware of this, the architect can withhold payment from the contractor to protect the interest of the owner. And when the owner does issue a joint check, it means that neither the contractor or the sub can cash or can deposit the check in the absence of the endorsement by the other. So the purpose of this is that it allows the owner to have some degree of assurance that when it does make payment, the indebtedness to the subcontractor or supplier has been satisfied. And then of course that limits the exposure that the owner has to potential lien claims. Sara, I can tell you, I have never run into this. I've never had to use this feature or been involved with a project or dispute where this has been an issue. But have you ever been a part of anything like this? It seems like it would be a pretty rare instance.
I have been on a handful of projects where this provision was implemented. It's where the owner had very, very good cause to believe that money wasn't properly being paid to subcontractors despite representations and payment applications. So yes, I have seen owners rely on this and start issuing joint checks.
And okay, so question, like after that moment, like did the project just keep on going? As I mean, that seems to like to me that would seem to like kind of strain relations a little bit, right?
Definite strained relationships. Yeah, the project kept going, but there was a surety bond claim shortly thereafter on the performance bond.
So it didn't go, it kept going, but not swimmingly. I think.
Exactly.
Okay, so I am, yeah. See, people think this is, you know, looking at provisions of the A201 is boring, but every once in a while you get some good stories out of it. Sarah, I am going to turn it over to you, and you are going to talk about lien waivers and release forms.
Yeah, well, thank you, Mike. So as we briefly touched on earlier, AIA Contract Documents has developed various lien waiver forms. And lien waivers are really a great way to avoid lien disputes on your project. Generally speaking, they memorialize that the contractor has waived its right to enforce a lien claim. So the contractor, after it's been paid, cannot later come back and place a lien on the project. No surprise lien claims on the project. And this gives upstream contractors, owners, and of course lenders reassurance that the project is going according to plan as the work progresses. And just so everybody's aware, I'll continue to say the words lien waivers because it's a lot easier, but it's a lot easier than saying lien waivers for lien claims or payment bond claims. But everything that I'm saying applies to both lien claims as well as payment bond claims. So as for some background on lien waivers and liens in general, many state statutes establish a contractor's right to assert a mechanic's lien or a payment bond claim after performing work. And similarly, states have laws recognizing that the right to enforce lien claims may be waived. And this waiver is usually done by a written agreement between two entities on the project, and it's commonly referred to as a lien waiver. On construction projects, signing a waiver is a standard step of getting paid. Mike talked about this earlier in the presentation. Contractors are often required to submit these as a condition for payment, and that would be either under the terms of the contract or under statutory law. And the name lien waiver and release forms is inconsistent across the US, unfortunately. So it can get a little confusing when people are referring to these forms. So in my experience, I've heard them referred to as waivers, releases, and lien waivers. The next slide. As for our sworn construction statement forms, contractors are also often required to submit these with their payment applications, but I'll admit that's only in certain jurisdictions that these are commonly seen. So this sworn construction statement form usually lists all of the entities who performed work or provided materials on the project. Like lien waivers, sworn statements are referred to by many different names in the industry. And I literally just said sworn statements, but the slide in front of you and our form in particular is titled a sworn construction statement. Also in my practice, I've heard them referred to as contractor affidavits or simply affidavits. And right off the bat, I'll say try not to get that confused with the contractor affidavits that Mike is going to be talking about later in the presentation. Unfortunately, there is no one standard one size fits all for the title of these kinds of forms. And
Yeah.
Mike, did you have anything to add?
No, I'll just say, I mean, it's a good point because, right, this is an affidavit. I mean, technically, this is a sworn statement that could easily be called an affidavit. But we're going to be talking about different types of affidavits later on in the program. Honestly, one of the reasons we put this program together was because we get questions regularly from folks who are like, well, which document do I use? They're kind of confusingly similar. So we're trying to sort that all out here. I'll tell you, Sarah, I've never, in jurisdictions I've practiced in the past, I've not come across sworn construction statements like this, but I mean, it seems like a decent practice, you know, to actually have use something like this on a project. And I know you're going to show us a sample of the form later. I think it's an interesting one, but it definitely threw me for a loop when we were first started talking about this, because I had never heard about it in practice.
Yeah, that's interesting. So I used to practice in Illinois, and I would commonly see them there submitted with each payment application. And then Michigan, the state of Michigan has specific laws about sworn construction statements and what needs to be contained within them. So next slide. So there are different kinds of lien waivers commonly used throughout the country. These variables are typically combined in some manner, such as a conditional lien waiver for progress payment or unconditional lien waiver for final payment. Of these, two types relate to the type of payment made to the contractor, and the other two relate to when the waiver of rights actually takes effect. So for number one, progress payment lien waiver forms are used where a payment is made prior to final payment, like a progress or interim payment, and the contractor waives its lien or payment bond rights in exchange for that progress payment. For number two, final payment lien waiver forms are used where the payment is made for, of course, final payment, and the contractor waives its lien and bond rights in exchange for final payment. For number three, conditional lien waiver forms are used where payment is to be made but has not yet been received by the contractor, and the contractor waiver of rights actually becomes effective when he receives that payment. And finally, unconditional lien waiver forms are used where payment has already been received by the contractor, and the contractor's waiver of rights becomes effective upon signing the form. And this is because payment has already been received by the contractor.
So Sarah, if I were to sum up here, if I'm an owner, I'm going to state the obvious here. If I've already made payment, I want the unconditional version of this. Is that right? And also, if I'm the contractor, if I haven't been paid, I better be very careful about signing an unconditional one, because I'm going to be relinquishing rights before I get paid. Have I summarized, made the obvious point here?
Yes, so much caution should be taken by contractors when signing unconditional lien waiver forms. But if I were to put on my owner's hat, I would want more unconditional lien waiver forms than conditional, provided that everybody's been paid as they should have been.
Absolutely.
So we have 4 generic lien waiver and release forms and 1 generic sworn construction statement form. The lien waiver forms include conditional waivers and conditional waiver and release on progress payment, unconditional waiver on progress payment, conditional release on final payment, and unconditional release on final payment. We also publish a variety of state-specific forms that may be considered in jurisdictions where the contents of those lien waivers are governed by statutory law. So generally, the generic forms acknowledge that the contractor waives and releases any liens, rights to assert a lien, payment bond rights, stop payment notices, claims for payment, and other rights for work performed on the project. Certain rights are accepted from being waived, including work performed after the effective date of the waiver, unpaid retentions, unpaid extras, pending modifications and changes, and of course, disputed claims. These exceptions are to be completed by the user when it's filling out the form. So now I'm going to touch on the specifics of the generic forms themselves. So the first one we have up is the G901, Conditional Waiver and Release on Progress Payment. And this form is intended when the contractor is required to provide a waiver that conditionally waives lien rights for work performed through a particular date, except for the rights listed under the exceptions paragraph at the lower half of the form. And that would be in exchange for a progress payment. And on this form, a contractor's waiver of rights is conditioned upon the receipt of payment as it's specifically described in the form. So you can see on the screen here, there are prompts for the user to complete a description of the payment method, the maker and amount of the payment, and the party to whom full or partial payment is being made if it's other than the contractor. And the next one we have up is the G902, unconditional waiver and release on progress payment. And this form is intended for when the contractor is required to provide a waiver that unconditionally waives and releases lien rights for work performed through a particular date, of course, except for those rights listed under the exceptions paragraph, and that would again be in exchange for a progress payment. Because this is an unconditional form, it contains bold language near the top of the form stating that the contractor acknowledges that it has been paid and has received a progress payment in a specified amount for its work performed on the project for the period covered by the progress payment. So we tried to make that obvious, and so users will actually read it to know what they are signing with that bold language.
Yeah, it's bolded for a reason.
Yes. Our third one is the G903, conditional waiver and release on progress payment. And this form is intended for when the contractor is required to provide a waiver that conditionally waives and releases lien rights for work, of course, except for those listed under the exceptions paragraph towards the bottom half of the form, and that would be in exchange for final payment. And on this form, a contractor's waiver of rights is conditioned upon the receipt of final payment as it's specifically described in the form. So similar to that G901 that I was mentioning earlier, the form contains prompts for the user to complete a description of the payment method, the maker and amount of the payment, and the party of who is going to be receiving the payment if it's other than the contractor. And as for our last lien waiver form, we have the G904, unconditional waiver and release on final payment. And this form is intended for when the contractor is required to provide a waiver that unconditionally waives and releases lien rights for work performed, except for those listed under the exceptions paragraph. And so similar to the G902, this form contains that bold language stating that the contractor acknowledges that it's been paid and it has received a final payment in a particular sum for the work that it's performed on the project. Unlike the G901 and the G902, this form, as well as the G903 that I mentioned on the prior slide, is not tied to work performed through a particular date. Instead, it covers all of the work performed on the project, and this is because it's for final payment. That's for one of our last forms that I'm going to be covering. We have the G907 sworn construction statement. And this form is for when a contractor is required to provide a sworn statement describing the people or entities who have performed work on the project or provided materials in furtherance of the contractor's capital W work. In this form, the contractor swears that the table lists a correct description of the type of work furnished by each subcontractor and supplier, the contract sum with that sub or supplier, the total sum of previous payments made, the amount requested under the current payment application, and the remaining balance to become due to each sub and supplier. The contractor also swears that the table is a complete statement of all persons and entities that it's contracted with to provide either labor, services, or materials to complete its work, or any other entities that the contractor is aware of that may be entitled to assert a lien on the project. And I think a nice feature that we've added in here is that at the bottom of the form, we've included an end of document so that both users and recipients can know that they have a complete table when there are multiple pages, because I've definitely seen some of these forms that have many, many pages and it's hard to keep it all straight. So overall, lien waivers and sworn statement forms are great ways to avoid lien claims on projects. They generally waive the right to assert a lien claim or a payment bond claim on a project, avoiding the issue altogether. Sworn statements also provide clarity to both upstream contractors and owners as to which entities on the project have performed work and received payment, allowing everybody to ensure that the payment is making it into the correct hands. And as you saw, these are 1 to 2 page documents. They're brief forms, but they hold a considerable amount of weight. And it's absolutely vital that the parties, both the party signing it, the party receiving it. Everybody needs to understand the representations within these forms before signing them. And it's also incredibly important for users to be aware of whether the forms are subject to statutory requirements. So again, we recommend that users consult with an attorney when completing or executing these forms, because you certainly don't want somebody saying your lien waiver doesn't comply with the law, so we can't even rely on it. Now, Mike, I believe you have some other forms to discuss that are within our library.
I do. And just a couple of wrap-up points. It's probably worth pointing out here that all of the forms that you just mentioned, they date from 2022. So these are relatively new forms in our library. And I can tell you that, for years we considered creating lien waiver and release forms, but it's a pretty daunting task. As you can see, there's, state-specific ones, there's all different varieties. And then of course you have to do quite a bit of research to make sure that they're up to date over time. And up until somewhat recently, we had been reticent to do that. So, these are, if you are kind of familiar with our offerings from, you only check in on them every handful of years. These are new. These are not something that's been around in our library for a long time. So it might even come as a surprise to you that we do offer these at this point. Some of the documents that we have mentioned, that I'm going to be mentioning, have been around for quite a while in our library. So that's one thing. And then another thing, Sarah, is it sounds like the procedure here that you should be thinking through. Number one, there's a lot of ways to trip up when it comes to these documents if you're filling one out. So obviously, hire an attorney, let them help you sort it out. Then you need to be thinking about, is there a state-specific form? Am I in one of these state-specific jurisdictions that I need to have a state-specific form? If not, then you should be looking at one of our generic forms or general forms, and then picking between, like, do you need a progress or a final one? Do you need a conditional or unconditional? And again, there's some pretty serious ramifications to making those decisions. So I'm going to go all the way back to the start and consider hiring an attorney. Sarah, did I get anything wrong in that process there?
Not at all. I think you drove home the main points.
Got it. Thank you. Okay, so we've got a handful of more slides, and then if we have time, we'll do a few questions. I'm going to change gears a bit here. I'm going to show you 2 forms for a contractor to execute that really tie together the individual lien waivers and releases. And the first one is G706, 1994, Contractor's Affidavit of Payment of Debts and Claims. And I have to admit that this is a document that is probably one of the more misunderstood documents in our library. First and foremost, please understand that this is not a release or waiver of liens in and of itself. It is exactly what the title says it is. It is an affidavit signed by the contractor certifying that payment has been made in full for all materials and equipment furnished, for all work, labor, and services performed, and for all known indebtedness and claims against the contractor for damages arising in connection with the performance of the contract for which the owner or the owner's property might in any way be held responsible and encumbered. So if you're using an A201 on your project, one requirement, I mentioned this earlier, but one requirement that the contractor's got to achieve before receiving final payment is executing an affidavit like this. And that's all the way back, in section 9.10.2 of the A201. And the G706 works to satisfy that requirement when it's filled out properly. So in other words, literally executing this form is a condition precedent to a contractor getting final payment on a project using the A201. So a few features of this document: there is a exceptions section here that if there's some payments some debts that are outstanding, you can list those exceptions. And also there's a handful of supporting documents that can and probably should be attached to this document. For example, the G702 documents that I'll talk about in just a moment, G706A and 707. That's another contractor affidavit and a consent of surety should be attached to this. And also the release or waiver of liens for both the contractor and for the subs, individual subs and suppliers should be attached as documents as well. Also, this is a document that needs to be notarized. There's some important certifications going on here. So this is one, for that reason, this is a document that we've got a notary, should have a notary stamp and seal on it. Next is G706A, which is our contractor's affidavit of release of liens. And this is, again, one of the more misunderstood documents in our library. Even though it says release of liens right in the title, it is not all by itself a waiver or release of liens. Rather, the G706A is an affidavit executed by the contractor certifying that the releases or waiver of liens that are attached to the affidavit include everyone who performed work on the project or supplied materials to it, or that might have some kind of a lien claim on the owner's property. So the most important thing to understand, again, not a release of liens itself, but it should include as attachments all releases of liens from any party who performed work or supplied materials. We get a question about this document probably once a week that asks, is this a lien release? So sorry, I've kind of hit that home a few times, but for good reason. It can be a little bit confusing. So of course, this document deals with the problematic scenario of a general contractor or a CM handing you as the owner a bundle of lien releases, but you really don't know, is this all of the lien releases for the project? You can't see the ones that you don't have, right? So this affidavit actually requires that the contractor to certify that everything that you're handing over, everything that's attached to it, are all of the lien releases for anybody who's performed work on the project. And again, some of the other features that are common with some of the other forms that we have, I've got to list exceptions here as well. So if you know that there's some lien releases out there that you still need to get, you have to list those. This is something also that has to be notarized. And of course, the supporting documents would include all of those individual lien releases from sub-suppliers, from the contractor itself. And again, this is something, that I would not hesitate. I do not overlook this on small projects. I mean, this can be very important on small projects. This is as well as large commercial projects. I mean, this would have been very helpful for the homeowners in the scenarios that we brought up at the top of the hour. So long story short, both G706 and G706A are important ways to kind of wrap up documents to make sure that the contractor has paid all its debts on the project and turned over all lien releases. Okay, last two documents that we're going to talk about. G707 is intended for use on a construction project where the contractor is required to furnish a bond. This is a safeguard for the surety, who of course has either an obligation to guarantee payment or performance on the project. Typically, the conditions of the surety bond itself will require the contractor to get consent of the surety prior to receiving final payment from the owner. Also, if there's a surety bond on the project, the A201 requires the contractor to get consent of the surety bond provider in order to become entitled to payment, to final payment on the project. And that's something that I touched on earlier in the program as well. And lastly, it's important to note that the surety's approval of final payment to the contractor does not relieve the surety of any of its obligations under the bond. So big picture, what's going on here is that when final payment is made, the surety is potentially relinquishing, rights or avenues for money in case of a contractor default. So they want to know about final payment before it happens and have the right to consent or, reject to give consent to such a payment. And last document here is G707A, which is somewhat similar to G707, but it deals with reduction in retainage. G707A is a consent of surety to reduction in or partial release of retainage. Again, only going to be using this if you have a surety bond on the project, because the surety is entitled to use the retainage and the remaining contract balance to complete work in the event of a contractor's default. It may be a condition of the surety bond to get the surety's consent to reduce or release retainage on the project. Neither the owner or the contractor really wants to be in the position of giving the surety grounds to avoid obligations that they would otherwise have under the applicable bonds by not getting the proper consent executed. So I hope that this program has, for those of you who get a little bit confused by our forms, I hope that this program has given folks some assistance in kind of sorting out which forms are for what purposes and how to use them. We've got a couple of minutes. Molly, I know you're on the call here. Do you have any questions that we can try to address? It's going to be a little tricky to handle questions about these kinds of issues because we can't give legal advice, but we can, and most of the questions I assume we're going to get in this realm are going to be kind of specific to particular projects. But Molly, any questions that have come up?
You've had a lot of great questions come through. I'm going to try to give ones that I think you might be able to answer or might be good for the good of the group. One of them is, how does the G901/G902 relate to the G706?
I am happy to take that one. I was actually going to chime in. I think of the G706 as a cover letter, almost a cover letter for all of your lien waivers that would be provided as part of your payment application. So if I'm a general contractor, I would use the G706 or the G706 as like a cover page with all of my lien releases attached to it. And you can even, Mike, I don't know if you want to scroll back to slide 25, but you can see on the G706 that it says supporting documents attached here too. And then the second half of it is the following supporting documents should be attached here too if required by the owner. And you can see that first one is contractor's release or waiver of liens.
Absolutely, I agree, Sarah. I mean, this is one of the reasons why so many times throughout this program we have said something along the lines of supporting data or other supporting data. I mean, this sworn statement, yeah, lien releases are definitely supporting data to the fact that the contractor has been paid or that subs have been paid, but this can act as supplemental supporting data along those lines as well.
Good job. Okay.
Good question.
I think we have time for maybe one, maybe two, depends how quick you get through them. In the absence of a construction sworn statement where it is not required, how would an owner track payments?
That's a good question. So one, I mean, your typical application, I'll start, Sarah, if you want to, I'll filibuster long enough so you can come up with the right answer. So, your typical applications for payment are going to come, at least if you're using our documents, that'd be the G702 and the G703. That G703 document is often referred to as a schedule of values, and it's going to have all of the various components of the work that are listed there and amounts that have been paid. It might even have subtrades listed there. So you really should be paying attention, I suppose, to, are you getting lien releases from all the people that are listed and all the subtrades that are listed in the G703? But the G703 is really the best way, for a contractor, short of a sworn statement like the one that Sarah's been talking about, for an owner to understand kind of how money is moving through the project, what items, the architect has, in some way approved when it comes to their review of the applications for payment. Sarah, you want to correct me on anything there?
No, Mike, you hit it out of the park. When I was on the surety side and things went sideways on a project and I would have to try and analyze what went wrong, why are all these subs making lien claims on the project? That's exactly what I used in the past to try and figure out what payments went where and to whom. So I think that the payment application or schedule of values is really your best option.
Excellent. Ollie, you got time for one more?
Sure, one fast one, really, really fast. In the absence of a construction sworn, oh no, we just did that one. I'm so sorry. For the G907, what is an owner's recourse if a contractor perjures the sworn statement and payment has been made?
Oh, wow, good question.
I mean, then you're in litigation.
Well, you're in litigation. Well, this is definitely one I'd want to research. But I mean, like, aren't you now being in the realm of like fraud, right? If you have done executed an affidavit, it's notarized, you're certifying things, you're certifying payments that have been made to contractors, and then it's just blatantly wrong, right? You have not made those payments. I mean, you are getting into the area of fraud, you're getting into damages that are going to go far beyond just a breach of contract kind of a scenario. Sarah, any thoughts?
No, that's exactly what I was thinking. Like the first time you're really going to use it after you've started up a case is in a deposition. So yeah, I unfortunately think you're in shaky grounds once your case has already started. But you can also use it before filing an actual case, and in case things have gone wrong and attorneys are involved, you can say, hey, we have this document that you swore under. So I would maybe use it to try and settle a case before any claim is actually filed.
Lots of good questions about the G907. I'm not surprised because it's probably the least common form that we've mentioned.
Yeah.
The one that's some jurisdictions you'll see it, others you won't. But I can definitely see the use to it because it is just quite frankly better in some ways than like a G703 at actually tracking through payments that have been made to individual subs. The G703 helps you out, but I think that sworn statement can be even better than that. So, Sarah, do you have anything else?
Just if you want to go to the next slide, I know we weren't able to get to all the questions, but here's our resources and contact information page. If you're emailing, you can email us any questions that you might have, and the email is second from the bottom that I would recommend you actually send it to, which is docinfo@aiacontracts.com.
Excellent, absolutely. And we've got a bunch of other resources on our Learn page and YouTube as well. So everyone, thank you very much, and thank you for the great questions.
Yeah.
Appreciate it.
Thank you so much.